Today in SERDNA Talks, we're going to talk about the probate process, and this is one of those videos that I think I could cover in 30, 40, 50 videos or more, who knows. So today we're going to start with the basics. Just remember this, I am not an attorney and I will never ever be one. Yet I have great information that I think you should know. So if you're thinking about starting a probate process, talk to your attorney to get started and then come to us so that we can help you with your real estate needs. So what is probate? Well, probate is the legal process of managing a person's estate after they go to heaven, or in plain words, when someone dies. Heirs are persons who are entitled to receive a decedent's property if the decedent died without a will. And beneficiaries, on the other hand, are persons who are named in a decedent's will to receive property. And the person who will represent the estate and handle the probate process is given certain powers by the court to complete the estate administration. In an ideal world, the person that you name in your will to administer your estate will be the executor. But if you die without a will, an administrator or executor will be appointed by the court. And in most states, the duties of the administrator and executor are very similar. And today, more and more states are using the term personal representative to describe the person handling the estate instead of saying administrator or executor. And as usual, the real estate process changes from person to person, and especially during a probate process. So talk to your attorney and real estate agent because this can be very, very complicated. One of the things that you will do is to file an application, and this one will be filed with the probate court either to inform that a will be admitted to probate or stating that X person died without leaving a will. Then a hearing will be held in order to provide proof of death, which is crazy because once you're dead, right? There's nothing else you can do. Why do you need to prove that you're dead? But whatever. A testimony from a family member or from a witness might be enough. And at the same time, the court needs to know if there is a will or not. And if there's a will, then some type of document will be issued by the court giving the personal representative naming the will power to act for the estate. And this document could be called something like something very boring: letters of administration, letters of authority, letters testamentary. And if there's no will, then things will get ugly and the court will issue some type of document identifying the heirs of the decedent. Keep in mind that whether named in a will or not, a person to act as a personal representative for the estate will be appointed by the court. And the personal representative must meet the qualifications of the estate status. So make sure to talk to your attorney about it because each estate is different. And one of the first steps will be the notice of death. And this one will be published and it will be sent to the heirs and beneficiaries. And guess what? A notice will be sent to creditors to permit them to file claims against the estate, which is insane. So much greed. Also, banks, of course, financial institutions, etc. will be notified. And the personal representative must do an inventory and collect all of the assets of the decedent. And this may include things like transferring title of the assets into the name of the estate until the assets are ready to be distributed to the beneficiaries. When such assets are collected, the personal representative will manage the assets during the estate administration. And the personal representative will be making an inventory of the personal property. Things like household goods, you will find art, jewelry, Porsches, motorcycle, airplanes, etc. And the representative will arrange for the safekeeping of such assets until the distribution to the beneficiaries, of course. And once all the assets have been accounted for and are in a safe place, then those assets will be appraised in order to obtain a fair market value. At the end, the personal representative will pay the decedent's debt, plus all its expenses such as attorney fees, appraiser fees, probate fees. So basically, if you are a Porsche lover, and if you don't have a trust, and if you have a warehouse filled with the most incredible Porsches, and if you die, then all those awesome cars will be sold in order to pay for all your expenses. But you know what's funny? Or, well, not really. Even if you are already dead, you'll still have to pay taxes. And that's something that really blows my mind. If there is more than $600 of income during the administration of the estate while the probate process is happening, then the estate must file an income tax return. And if the administration of the estate continues for more than 12 months, then the personal representative or executor may have to file more than one income tax return for the estate. The personal representative will be responsible for paying any income tax liability of the estate during the administration as part of the debts and expenses of the estate. And if federal state tax is due, the tax must be paid when the state tax return is filed. So as you can see, probate cases can be a little complicated. And that's why I think I should do more videos about it, because this is such a long and complicated topic. We will talk more about the probate process in another video. If you have questions, remember to subscribe to SERDNA Talks and to share all my videos with your friends and family. I have to go. See you soon. Ciao.